So the state of California is now begging the Ninth Circuit en banc panel to send the Duncan v. Bonta California magazine ban case back down to Judge Benitez for reconsideration and for the case to start all over again. So let's talk about this. But real quick before we jump into this video, if you believe that bans on magazines is unconstitutional, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the detail sections. So like I said in the intro, the parties in the Duncan v. Bonta California magazine ban case have filed their supplemental briefs to the Ninth Circuit en banc panel, which were requested by that panel. In the state of California's brief, they are essentially begging the Ninth Circuit en banc panel to vacate the Judge Benitez prior ruling and to remand the case back down to him for the case to be restarted and reconsidered. This is obviously a stall tactic by the state of California, since they know that the Supreme Court's Bruin decision will inevitably result in this ban in California being found unconstitutional. So they are trying everything they can in this brief to stall the case out and to get it remanded back down to Judge Benitez. So for those not aware, Duncan v. Bonta involves the possession and purchase of so-called large capacity magazines in the state of California. California Penal Code Section 32310 bans the buying, selling, possession, etc. of magazines that hold more than 10 rounds. This law was challenged in the district court in the Southern District of California before Roger T. Benitez, or St. Benitez as he's known in California. In his original ruling, Judge Benitez granted what is known as a summary judgment motion, which essentially found that this law in the state of California did in fact violate the Second Amendment. And this led to what is known as Freedom Week in the state of California, where millions of magazines were purchased during a single week period of time. Millions of magazines were purchased and brought into the state of California. Well, after that week period of time, Judge Benitez had to issue a stay on his own order because essentially the state of California was going to appeal up to the Ninth Circuit, which they did. When this case made its way up to the Ninth Circuit, it was heard originally before a 3-judge panel in the Ninth Circuit. The 3-judge panel reviewed the case and issued a decision, essentially agreeing with Judge Benitez and his ruling down below. Well, after California lost again before that 3-judge panel in the Ninth Circuit, they then sought a rehearing before an en banc panel in the Ninth Circuit, and essentially that is just a larger panel of judges in the Ninth Circuit. The en banc panel, in reviewing this case, ultimately sided with the state of California, and in coming to its decision, the en banc panel rejected text, history, and tradition as the test that should be used instead of their continued use of what is known as the two-step approach. Essentially, the decision before the en banc panel was a battle between tiered-based scrutiny and text, history, and tradition. The majority found that tiered-based scrutiny would win out, while the dissenting opinions on the en banc panel advocated for text, history, and tradition to be used. That decision by the en banc panel was then appealed up to the Supreme Court. The Duncan case was then put on hold at the Supreme Court level until the Supreme Court ruled in Bruin. Well, the Supreme Court recently ruled in Bruin, and they affirmed that text as informed by history and tradition is the appropriate test, and they expressly rejected the two-step approach, which the Ninth Circuit and the en banc panel in Duncan used. The Supreme Court then granted, vacated, and remanded the Duncan case back down to the Ninth Circuit en banc panel for a reconsideration in light of Bruin. The parties in this case then submitted their briefs to the en banc panel, arguing how they believe that the Bruin decision has impacted this case and what the en banc panel should do from here. California, in their brief, argues that in New York State Rifle and Pistol Association v. Bruin, the Supreme Court changed the legal landscape for analyzing Second Amendment claims. Instead of the two-step test adopted by this and most other federal courts, Bruin directed courts to apply a standard rooted in the Second Amendment's text as informed by history. In light of Bruin, California respectfully submits that this court should vacate the district court's judgment and its order enjoining the Attorney General from enforcing California Penal Code Section 32310 and remand this case back down for further proceedings. They go on to argue that the Supreme Court has dramatically changed the ground rules with respect to plaintiff's Second Amendment claim. Vacate and remand is necessary to allow the parties to compile the kind of historical record Bruin now requires, and would allow for the district court to address a number of important issues raised by Bruin in the first instance. They also point to the fact that the Ninth Circuit has already remanded other cases back down to district court judges. Those cases include Rupp, Miller, and Young v. Hawaii. So they're using that basis and those other cases as a basis to say that the Ninth Circuit en banc panel here should remand this case back down to Judge Benitez as well. So in their brief, the state of California puts all their effort into getting this case remanded back down to Judge Benitez. That is because they are simply stalling for time, and they know that their best hope is to simply drag this case out for as long as possible and hope that down the road, some of this legal aspects and some of these legal arguments change. Now, the plaintiffs in this case, which are represented by Michelle and Associates, also filed their briefs to the en banc panel. In their briefs, they argue that magazines are in fact protected by the Second Amendment and that there is no history or tradition of restricting firearms from being able to fire more than 10 rounds. Therefore, under Bruin, they argue that the Ninth Circuit should find that this law is in fact invalid. Also, they argue that it's finally time for the Ninth Circuit to definitively resolve this case once and for all and stop stalling this out because it's already been going on for 5 years. In their brief, they state, there is no need to remand this case to the district court to reach the glaringly obvious conclusion that California's magazine ban violated the Second Amendment. While this case has been governed until now by the defunct two-step test, that has in no way precluded the parties from developing the record necessary to inform the inquiry that Bruin mandates. The parties have already developed a full record on whether the banned magazines are typically possessed by law-abiding citizens for lawful purposes. Parties likewise have already developed a full record complete with historical documentation and expert testimony on the relevant history and tradition. Indeed, both parties have and had to develop the record because this court's two-step test treated long-standing prohibitions as outside the scope of the Second Amendment. Both parties thus had every incentive to develop the historical record, and develop it they did. The state meanwhile tried, albeit in vain, to prove that such restrictions have a sufficient historical pedigree. The district court, the panel, and the en banc dissent thus were already able to conduct the historical inquiry that Bruin reaffirms, and after a long march through the history, each concluded that restrictions on the possession of firearms magazines of any size have no historical pedigree at all. Given that procedural history in this now 5 years running case, remanding to the district court at this late date would accomplish nothing but delay. Indeed, remand here would provoke only head-scratching and needless delay because the district court has already twice conducted the historical analysis that it understood Heller to require, first at the preliminary injunction stage and then at the summary judgment stage. In short, there is simply no question asked by Bruin that is not already fully explored in the extensive record in this fully litigated case. The remaining issues are pure questions of law that have been aired out at every level, including before an en banc panel of this court. The time has thus come for this court to finally recognize what is undeniable after Bruin. California's magazine ban cannot be reconciled with the individual and fundamental rights that text, history, and tradition confirm the Second Amendment protects. So the battle right now is trying to keep this at the Ninth Circuit level. California wants this desperately to be remanded back down to Judge Benitez, and the plaintiffs simply want the Ninth Circuit to do the right thing and to apply the Second Amendment and the Supreme Court's decision in Bruin to review this case like they were ordered to and resolve this issue in this case after the 5 years instead of making it start all over again and for Judge Benitez to have to rule on this issue for a third time. The likelihood is, in my opinion, that the Ninth Circuit is going to punt this case. That is not the best case scenario because it drags this case out even longer. But even if this is remanded, it does go back into the hands of Judge Benitez that has already twice found that this law is unconstitutional, and the odds are that he will do that once again. He will rule the same way again. So that is where the California magazine ban currently stands. Now we're waiting to see what the Ninth Circuit en banc panel decides to do. But if I was a betting man, I would say that they're going to punt this case like they did in some of the others. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorithm rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.